The period from 1087 to the year 1200 is a period that marks the end of the reign of William the Conqueror, but also sees the consolidation and expansion of Norman rule under William's successors. Now, these are very crucial parts of history when we think about the formation of the English legal system, as well as the political and administrative developments that shape the future of England. So that's what we're going to be talking about in this lesson. Specifically, we are going to concern ourselves with the following periods of time. We're going to first talk about 1087 to 1100, which marks the period of the reign of William II, William Rufus. From this point, we will then talk about the reign of Henry I between 1100 AD to 1135, and then the Civil War period, known as the Anarchy, between 1135 to 1154. The final point is going to be something we touch on briefly in this lesson, because this is going to be the marking of the period of the Angevin Empire under Henry II from 1154 to 1189, the formal consolidation and real establishment of legal authority with the common law. This is going to be a topic, a chapter in and of itself that we're going to do after we've covered the Norman conquest. So bear that in mind, that we're going to briefly discuss this as sort of a context aspect of this lesson, but we're going to be giving that a lot more attention and unpacking a lot of those details in more specific detail in future lessons' time. So let's begin then. William II reigned from AD 1087 to AD 1100 and was the second son of William the Conqueror and became King of England following the death of William the Conqueror in 1087. Now, William II's reign was marked by his contentious relationship with both English society, specifically the nobility, as well as also the church. Now, he was nevertheless an effective ruler when it came to maintaining royal power, and his reign also saw a number of important legal developments. So, one such example of conflict and legal dispute concerned land disputes. Rufus's reign was characterized by the continued struggles over land and tenureship. William II did not hesitate to seize lands from other members of the Anglo-Saxon nobility and to reallocate them, should I say, to his own noble followers. He was frequently at odds with his barons, and there were numerous disputes over land holdings which required royal intervention. William II's ability to assert control over these disputes helped to establish the royal court, and especially to establish the royal court as the ultimate arbiter of such matters. These things reinforced the centrality of monarchy in land law, and this is why monarchy is spoken about so heavily when thinking about land law, is because of these different kinds of developments, from William I to William II. You also see a number of religious conflicts during the reign of William II. He had a strained relationship with the church, particularly the Archbishop of Canterbury, Anselm of Canterbury, over the appointment of bishops, as well as the relationship between the church and the crown. Ultimately then, these religious strains and these religious conflicts would lead to legal conflicts, with the king using secular courts to assert their control over ecclesiastical matters. As I mentioned when thinking about the role of Christianity in the Anglo-Saxon period, I noted that essentially this system of canon law would eventually start to become increasingly sophisticated and even become its own separate legal system that was distinct from the secular legal system that we have under the royal courts. And so the king used these secular courts to assert control over ecclesiastical matters, to essentially assert control over matters that would ordinarily have been the context of the canon law. What this ultimately did was lay the groundwork for the conflict between church law and royal law, which would not necessarily escalate too much during the reign of William II, but would escalate in the future reigns of other monarchs. while William II didn't necessarily introduce any major sweeping and widespread legal reforms, he still contributed to the eventual centralization of justice in the royal court. So, for example, his ability to handle and to assert control over land disputes, as I've mentioned, reinforced the centrality of monarchy in land law. And so his policies would lay the groundwork for the expansion of the royal judicial system in coming reigns. And one such example of this is through the establishment eventually of the Court of the King's Bench. After the death of William II in AD 1100, Henry I ascended to the throne. He would rule from 1100 to 1135. For those of you who are particularly poor at maths, that is a reign of 35 years, and is often regarded as one of the most significant kings, especially when we start to think about administrative and legal reform. So Henry I's reign was pivotal in consolidating royal power and further developing a legal framework that, again, as I mentioned, becomes the foundation for the English common law. So one such example of this is the Charter of Liberties in AD 1100. This was one of Henry I's first actions in taking up the throne, and this was the issuance of the Charter of Liberties. The Charter of Liberties was a document that was partially inspired by a number of the grievances that had taken place with and around the nobility under his brother William II. Now, the charter sought to essentially try and curtail some of the more important abuses of royal power, and instead lay the groundwork for a more formalized relationship between the monarchy and the barons, because William II faced a number of challenges in relation to conflicts and disputes, especially land disputes among members of the nobility. And his sort of quite strong attitude towards asserting royal control and royal authority would often cause tension between the monarchy and the barons of the nobility. This, of course, is very problematic when you start to think about the Magna Carta in 1215, which we'll get to in future lessons' time, but also remembering in the back of our minds that there is no system that really technically and formally keeps monarchs safe from overthrow and revolution. It is only the barons, nobility, and the military, which obviously is raised by the members of the nobility, that actually is able to keep the king in place and keep the succession successful and all these different kinds of things. So basically keeping the army happy and keeping the barons happy is something that is very important for kings to do during this period. And so the Charter of Liberties promised to uphold the law and to also protect the rights of the nobility, particularly in relation to issues of administration of justice and inheritance of property. And really, the Charter of Liberties is seen as and considered to be a very important precursor to the 1250 Magna Carta, which of course is far more famous for what it achieves, but it definitely just formalizes, the Magna Carta would just formalize many of the same principles that we see in the 1100 Charter of Liberties, a good century and a bit prior. In terms of the legal system in a more general format, under Henry I, we see further work to try and centralize judicial power. This is done through the strengthening of the royal courts and increasing their reach across the kingdom. The continued use of iterant justices was also a very important system. That these were royal justices who travelled around the country to hear cases from different regions of the kingdom. Again, this was essentially ensuring that you see that a uniform application of royal justice would take place. Unlike the local customs and local traditions system of the Anglo-Saxons, where a legal dispute would be potentially heard very differently in one part of England to another part of England, this idea of having royal justices travelling around the country to hear cases and to adjudicate using a legal system that is advocated by the monarch themselves and through the royal courts and administrative system is a way, of course, ensuring uniformity and standardisation of justice across the entire kingdom, and also to undermine the Anglo-Saxon legal traditions that had existed there previously. These justices were often instructed to visit local courts and to supervene and to supervise over legal proceedings and to ensure that royal laws were being accurately and adequately upheld. In addition to this, Henry I established a more formalised system of financial and legal administration. So creating, for example, the Exchequer, a department that was responsible for overseeing the kingdom's finances. Now, the word exchequer being the system to oversee the king's finances, of course, will be the word that is now associated with the person who lives at number 11 Downing Street, the Chancellor of the Exchequer, who is, of course, essentially the economics minister of the government of Great Britain and Northern Ireland. So the Exchequer not only handled royal revenues, but the Exchequer would also play an important role in maintaining the legal system, especially when we think about matters relating to landholding, taxation, as well as the king's rights over his subjects. So not only is the establishment of the Exchequer under Henry I an important financial instrument and a financial institution, but it is also very important for the provision of legal administration as well. Furthermore, we can see that under Henry I, the royal court would grow in its prominence. This is partly due to some of the issues that we've associated with this particular monarch on other points. So, for example, the use of royal courts and itinerant justices, for example. But legal matters, in addition to this, that had once been handled by local lords, were increasingly referred to the King's Court. And so the principle that the King's Court was the ultimate arbiter of disputes would start to take hold as more and more important cases in legal disputes were being referred to the King specifically. And so decisions made by royal justices set important precedents that would later form the basis of the common law. And that's a really important issue here, the doctrine of precedent and case law. The reign of Henry I saw the earliest development of case law in this regard, where judges would refer back to previous decisions that had been made in similar cases when they make rulings. Now, they never formalized this as the doctrine of precedence necessarily during this reign, but it, at the very, very least, gave us an indication of where the legal system was going to be going. It laid the foundation for the doctrine of precedent in English common law. So, in 1135, we see the death of Henry I. Now, the death of Henry I would trigger a civil war over the throne of England. The civil war was between Henry's only legitimate son. Henry's only legitimate son had actually died, should I say. This is why there was a civil war. There was no direct male heir, should I say. So in 1120, William Adelin, who was the only legitimate son of Henry I, had died, and this led no direct male heir. And so instead, Henry's daughter Matilda was supported by many, but then you also have her cousin Stephen of Blois, who had created a claim to the throne themselves, and in fact were rushed very quickly to be crowned king, such that Matilda couldn't get in there in any kind of meaningful sense. The result was therefore a prolonged period of civil conflict, during which the crown's authority would be undermined, and local lords, just like under the Anglo-Saxons, would begin to gain more power and prevalence. Again, there was a breakdown of royal authority. So you have the death of William Adelin in 1120, leaving no direct heir. You have Henry's daughter Matilda being probably the most likely to secure the throne, but then you have her cousin Stephen taking the throne instead. And so the result was the fact that there was a major impact that this had on the legal system. The anarchy had significant implications for what ultimately happened to the law at this time. The central monarchy was weakened, local lords and barons increasingly took the law into their own hands and therefore increased their own power and their own authority, holding their own courts and enforcing their own justice, decentralizing the system. Royal courts were less active and many legal disputes were resolved outside any kind of framework of a sort of unified system of standardized law. In particular, there was an impact on land law. So land disputes were particularly acute during this period, with both Matilda and Stephen attempting to secure the loyalty of various different powerful barons in order to try and secure the succession themselves. Landholding then became a key aspect of political power, and many individuals, especially those individuals who existed in the countryside, would rely more on local lords for justice than on royal courts. Ultimately then, all of this lack of centralized authority would delay the development and the building of a common law system during this period. It wouldn't be until Henry II, which we're going to talk about in a second, that the common law would start to develop in the way that it does. Arguably, potentially, let's say that Henry I's only legitimate son didn't die in 1120, and there was a direct male heir, and there was a complete reign that takes place. Maybe you could argue that that could have led to the development of the common law a little bit earlier, but at the very least, this civil war definitely hampered any legal administration or centralization of legal administration in this period. After the death of Stephen in 1154, the successor was Henry II, who would work to try and restore central control and to try and reform the legal system. And so Henry II is where we're going to finish this video, and the next few lessons are going to talk about some of the specific aspects of the Norman rule and the Norman legal system, such as land law, feudalism, crime, etc., etc. And the reign of Henry II is something that we're going to talk about in far more detail in the future. It's going to be its own topic, the sort of Angevin empires. And so I'm just going to briefly go through this in this lesson here. Henry II ascended to the throne in 1154 and is probably the most important monarch when it comes to the development of the common law. And so really, he is credited for creating the common law, for developing the common law system in England. One of his first priorities was to try and restore the strength and authority of the royal courts after the kind of Matilda and Stephen debacle led to a further decentralization of authority. So this was done through a number of means. He would expand the use of itinerant justices who would travel across the country and hear and enforce the king's laws. This would help to assure that there was royal authority and royal justice would be applied as a standardized system as we had previously. But we also see the introduction of a number of assizes or assizes. These are known as royal decrees that essentially try to formalize the legal procedures. What these royal decrees did was address specific legal issues concerning land disputes, concerning criminal offences, concerning the trial process in various different disputes. The most famous of these was the Assize of Clarendon in 1166. What this did was introduce a system of presentment where local juries would report suspected criminals, and this introduces for us the concept of the trial by jury. Furthermore, we see that Henry II's reforms diminishes the power of local feudal courts and instead strengthens the role of the royal courts themselves. The king's court became the ultimate authority in legal matters, and the idea of justice being dispensed by the crown was a concept that would begin to take hold and to take shape. We also have the development of case law. A growing body of judicial decisions began to form the basis of what eventually becomes the common law. Judges in the royal courts started to rely more heavily on past decisions when ruling on cases, and this is what creates precedent. This is what creates a legal system that develops legal principles. Not only has, let's say, a judge ruled in this particular way on this case, but this judge has created and set a precedent for how to rule in this way if future cases of a similar nature come about in the future. And that is really where we start to see not only just disputes being heard and disputes being adjudicated on through judges and through a royal court, but instead actually going to judges and judge decisions to find and to think about what legal principles are, to think about what the legal principles are. That's what the common law is. It's not just a system by which a dispute is dealt with by the royal courts. It is a system of law. It is a development of legal principles that are developed through legal precedent and developed by judges and by royal judges and by royal courts, in order to understand what to do in a situation and what the correct law is in a particular dispute. So all of these things are very, very important. You also then finally have a number of clashes with the church. So Henry II's attempts to control both secular and ecclesiastical justice led to a very famous confrontation. This was a famous confrontation with an individual by the name of Thomas Becket, who was the Archbishop of Canterbury. Ultimately, Becket resisted Henry's attempts to bring the church under royal control and royal authority, particularly when it came to matters of legal authority. And so all of this culminated in the murder of Thomas Becket in 1170, an event which would deepen the divide between the church and the monarchy and highlight the growing importance of law and justice when it comes to royal and monarchical authority. So as I said, we're going to get through all of this in more detail in future lessons' time. This is going to be its own chapter in the history of English law. But to sort of just wrap things up and to conclude here, the period from the end of William the Conqueror's reign all the way up to the year 1200, sort of circa 1200, was marked by a significant development in the English legal system. You have firstly the William II reign, you have Henry I, and then you have the civil war between Matilda and Stephen, but ultimately the centralization of justice and the establishment of the common law takes place under Henry II. Now, the next lesson is going to focus on the rise of Anglo-Norman culture and the legal institutions that are formed as the result of this establishment. But then in the future lessons' time, essentially what we're going to do is talk about the system of land law and feudalism before moving on from there to start to focus on the reign of Henry II in far more detail and the birth of the common law as a legal system that is obviously of paramount importance to us.